I'm not really worried necessarily about the money. I'm trying to figure out why you didn't do anything.
I've just been all over the place, so but I am trying to get them off my record. So,
Pardon?
I said I've been all over the place, but I am trying to clear my record. So that's what I'm here.
The judge wasn't concerned about the money. He wanted one answer. Why hadn't the court's requirements been followed? The hearing revealed years of unresolved probation obligations, including missed reporting, incomplete requirements, and unpaid financial obligations. The defense asked the judge to consider a fresh start, pointing to recent employment and time already served. But after a brief exchange with the defendant, the judge had to decide what would happen next. And the decision came quickly. Let's step inside the courtroom and see how this case unfolded.
Public Defender Natalie Pigman, on behalf of Mr. Grimes, who stands to my right, please state your name for the record, sir.
Teresa Claire on behalf of probation. Your Honor, Mr. Grimes is before the court for a violation of probation hearing. Mr. Grimes was sentenced in this case in September of 2015. He was originally given a hiatus sentence. That was revoked back in 2016. Since that time, Your Honor, Mr. Grimes is still in violation of any of the court's orders, in that he has a balance of $1,503. He did have a payment that was made to the court in April of 2023. However, that was due to a garnishment that the court had set out. There is a balance of that, of restitution, that is $265.05. Mr. Grimes failed to report to probation, failed to complete the class, failed to complete 25 hours of community service, failed to provide proof of his GED, failed to provide proof of employment. He also has new pending cases, 1 out of 42, that's a domestic violence alleged date of offense of November 7, 2019. He has a pretrial in that matter on the 27th in 2 days. He also has a pending case out of 14B, an aggravated assault, an alleged date of offense of May 31st, 2024. He has a pretrial in that case in July 25th of 2024. Given the noncompliance by Mr. Grimes, probation is recommending 93 days in jail with credit for 13 days served, that he served the balance, waive remaining terms, accept his financial obligations, and discharge him from probation.
Thank you, Your Honor. I did have the opportunity to discuss both the alleged violations of probation as well as the recommendation with Mr. Grimes. He does acknowledge the violations of probation. Our request at this time is for the to respectfully request the court to considering discharging him from probation without improvement. Of course, still imposing the financial obligations. We are respectfully requesting the court to consider not remanding him today, as he did serve 13 days already so far for his violations. He does have full-time work, employed there full-time for 4 months. His 2 cases that are pending are misdemeanor matters and are still pending at this time. We are respectfully requesting the court to discharge him from probation without improvement and to not impose any additional jail time at this time.
Anything you want to say?
I can pay $150 today if needed.
Pardon?
I can pay $150 today.
I'm not really worried necessarily about the money. I'm trying to figure out why you didn't do anything.
I've just been all over the place, so but I am trying to get them off my record. So,
pardon?
I said I've been all over the place, but I am trying to clear my record. So that's what I'm here.
Ms. Valero, that date of offense on the domestic was in 2019, correct?
Correct, Your Honor.
And what, was he just on bench warrant stat? What?
I believe so. I can verify that for you.
And then you have while she's looking at that, you have a brand new, while you're on this case and a bench warrant on the other case, you got a new ag assault that you picked up on May 31st.
That's an alleged case, though.
What?
That's an alleged case, though. I was arrested for warrants. They just put that case.
I realize it's alleged. They're all alleged until you come to court to take care of it.
Yes,
But
sir.
I mean, Jesus. All right. Anything else you want to say?
No, sir.
We're going to waive all remaining terms and set the financial obligations. Discharge him from probation without improvement. Defendant is sentenced to 93 days in jail. I'll give him credit for 13. Defendants served a balance. Defendants remanded.
Damn, he going to jail. Damn, he going to jail. That's
Washington.
my name is Demarcus Daquan Washington.
Your Honor, there are two files in front of you. One, he owes about $500 on, or $525, I think, 507. He paid a $500 bond. On the other one, I think he might owe $325, and he paid a $300 bond. He just got out of prison in the last couple months. He's just getting back to working. I'd ask that you just apply
Did he pay the bond? 'Cause I had the bonds being set, but I don't have that he paid them.
I'm not sure. JAS just reflected that he paid bonds on both cases.
You see bonds on either? I see the bond set, but I don't see payment.
Well, if I misread JAS, I apologize. I'd ask then to adjourn the show cause so he's been in prison for 5 years, so he's kind of just getting back on his feet and back to work.
Are you working currently, sir?
Yes, I work at Deluxe Tents and Events in Belleville. And Judge Simpson, I just wanted to ask you, as you know what I'm saying, somebody who just did 5 years in prison, and you know these cases are misdemeanors, and I did just get sent to prison from Washington County. I was wanted to know if you could run anything concurrent with the time I've just done, because I just came home May 29th.
Sir, I don't have any proof that you did any time in prison. I don't have any of that in front of me.
Okay. Well, I'm saying that.
So I'm going to adjourn this to July 10th, 2024 at 9 a.m. Council, get together something for me to take a look at regarding that.
That's
As well, thank you. As well as in case if I decide that he needs to at least pay one of these, how he would do that.
Sure. Thank you.
Thank you.
So July 10th.
July 10th.
Okay.
And next, make sure that you understand how to work Zoom so you're not interrupting my court.
Yes, sir.
Thank you.
Assistant Public Defender Natalie Tate with it on behalf of Ms. Ducia. Please state your name for the record, ma'am.
Crystal and Dusai.
Dusai.
I apologize.
Okay. All right, go ahead.
Thank you, Your Honor. Today is the date and time set for the motion to set aside. To my understanding, Ms. Dusai meets all the statutory requirements and the Attorney General does not have any objection. We'd respectfully request the court to grant our motion.
And, ma'am, is there anything you want to say?
There's a lot I want to say, but I'll keep it simple. I've stood in front of you many, many times. So I'm a woman in long-term recovery. I have 15 years sober now. And because of that, because of grace that I was given many times over, I'm able to help others. So I have more letters behind my name than I do in my name as a result of the gifts of recovery. I currently run an inpatient treatment center where we have 45 residential inpatient beds, 10 withdrawal management, and still am very involved in recovery. I advocate at a state, local level for Narcan access and harm reduction, and but that wouldn't be possible if I was sent to prison instead of treatment, and the courts didn't see hope in me when I didn't see hope in myself. So I am grateful for the grace that honorable judges such as yourself have shown individuals.
Well, I got your name wrong.
It wasn't the first time you got it wrong, Your Honor. Many times over the years. So.
And I do remember you. And one of the great things is, and as I was going through the files, that I think it must have been, I want to say 2005, 2006. I don't have the ROA, somewhere around there. And anyway, one of the things is that you often wonder, as you're going through giving the orders, what's going to happen to these people? Do you know, because sometimes they have to do things and I don't see them later on. Sometimes I'm blessed that I get to see individuals and kind of see what they've done with their life, and really do hope that maybe in something I did, but it was really them, but maybe in something that I did that there was an impact. And I certainly can see it in this case. You've done well for yourself. Very well. And so the court in reviewing the petition to set aside the conviction in this case, and the Attorney General and the prosecuting attorney having an opportunity to be heard and having no objection, the court does believe that circumstances and behavior of the applicant from the time of the applicant's convictions to the filing of this application do warrant setting aside the conviction in this case, and is consistent with justice and the public welfare. And I signed your order. Congratulations.
Thank you, Your Honor. Can I get a copy today?
Well, everybody's going to want to.
That's like wild.
Yes, we will make sure you get a copy.
Thank you.
All right, you take care. Okay, go ahead. This is your motion.
Thank you, Your Honor. Today's date and time set for a motion for reconsideration on reinstatement of conviction. To my understanding, the prosecutor did not have a response to this motion. I'll keep my allocution very brief. I know Your Honor has reviewed the motion. As Your Honor is aware, this honorable court reinstated Ms. Brooks' conviction back on May 14th, 2024. Under MCL 780.621H, a conviction automatically set aside may only be reinstated for two reasons. One being the conviction was set aside in error, or two,
That's not what you stated in here, right? Didn't you state that it was an and?
Yeah, and there has been a judicial termination
No, you put in your motion in paragraph 10.
Yes.
They only be set aside for two reasons. One, the conviction, and there has been a judicial determination. That's incorrect. It's not an and.
That is what is stated in the...
There are two sections under which it can be set aside.
Yes, there are, Your Honor. Under MCL 780.621H, the memo that May 4th, 2023 memo by the Michigan Supreme Court has stated, and I am reading from their memo, a conviction automatically set aside may only be reinstated for two reasons. One, the conviction was set aside in error, and two, there has been a judicial determination that the defendant has failed to make a good faith effort to pay restitution. That is pursuant
under that one section.
Yes, Your Honor. And this conviction was automatically set aside, and then
first of all, it was set aside in error. Had you looked at it, because it shouldn't have been set aside in the first place? But go ahead.
It was set aside. Ms. Brooks had been making payments on her statement. There was no judicial finding that there was
I'll make the finding then, so we can get to the end of this, because I went through a lot in terms of Ms. Brooks trying to make sure that she wasn't double dipped. I think that this motion for reconsideration, one, was filed in bad faith because of what happened in this case. And a motion consideration also is not entitled to a hearing unless the court does so, and unless it is requested that one, but I set it for a hearing. So here's what I will say. First of all, the conviction was set aside in error. I went through great pains to make sure that Ms. Brooks was not being double dipped. It turns out that two portions of the restitution that were owed there were two parts to it. One that was in the court, one also that was in part of a civil action. She elected to pay in full the civil action, has not made, in this court's mind, absolute good faith effort to pay forth this second portion. She has been making payments, but she could have certainly, with this action, elected the opposite. Hence, I would find that that's not in good faith. She's made her efforts, but I don't think in good faith has made the effort, and also has missed for significant periods in time, has missed for significant periods in time the payments that she initially had agreed upon to pay. So in that respect, and the court believes while she missed those payments, she could have made those payments, but did not. And so for those reasons, court would find that the court doesn't believe that she's made a good faith effort. The motion for reconsideration is denied. You'll file an order to that effect for my signature.
Thank you, Your Honor. Assistant Public Defender Natalie Pate with and on behalf of Brandon Cole again. Please state your name for the record, sir.
Brandon Cole.
So when we were interrupted by the power, so go ahead. Anything else you want to tell the court?
Oh, yeah, I believe Mr. Cole was about to speak when the power was on. Go ahead, sir.
I was just trying to say, Your Honor, that I am sorry for my actions. I am a strong man, strong Black man, Christian man, and I am in seeking therapy right now. I have a lot of little ones that I do work for and take care of. I am a very important piece to them, and I'm trying to do better, Your Honor. I really am, and that's all I really have.
Scott, I mean, my problem is when I look at your prior arrest and convictions, the nature of those, and that you're currently on a bench warrant status out of 15 and an indecent exposure charge, all of that taken into consideration. It's the sentence of the court, $125 statutory fee, sentence the defendant to 90 days, Washington County Jail, credit 6 days served, defendants to serve the balance, defendants remain. Mr. Woolridge present.
Your Honor, we've been unable to contact him. He was in court yesterday with Mr. Hall. And I know he works at night. I imagine he's still asleep from working. He's shown up all the time for every other appointment. Basically, I was going to ask for an adjournment. Mr. Hall is trying to get Mr. Woolridge straight with the Secretary of State.
So you were able to get out of bed, but he wasn't?
You know, I'm very young.
Well, there's a yeah, that is funny. I'm going to issue a bench warrant, bond $5,000. I'll give a 10% privilege. If you happen to locate him or he happens to wake up, there's a procedure to try to set that aside and reset it. But at this time, I'll issue a bench warrant.
All right. Thank you.
Thank you. Mr. Vincent, I'm young. Really? Court calls the case, People versus Stephen Richmond.
Your Honor, I'd like to motion.
Hang on. Both of those proceedings are in person. You would what?
I'd like to get a different lawyer, please.
Well,
either a chance to get my own, because any attorney that tells me that I'm going to get a harsher sentence.
Mr. Chase, I will not say anything else.
Why?
Sir, if you wish to get a new attorney or hire your own, you may. I don't.
Thank you.
I don't. I'm not going to move any of the dates. I'm not going to do anything along those lines.
That's
fine. You'll have to hire one, and they'll be stuck with the dates we've set.
Yeah, that's fine.
Okay. I'm glad we worked that out. Thank you. Get left there in custody, so it's going to apparently be a minute between cases. How did this happen? Text. I don't know. I'm not even talking to you. No, I'm not talking to you, Emily. I give up.
Okay, bye.
Court does call the case. Joanne, you set this docket up?
Yeah.
Okay. No, that's okay. I need the rest. Court. I don't know. I'll probably run out. Court does call the case. People versus Jason 17. And what I'll do is let's get an answer as to how he's going to get down here. I don't think his housing will be jeopardized between now and then if I just kick it out a week. And then we can also make sure that in terms of his medical care and other things. Yes, sir.
How am I gonna get down here? Is that what you said? My place is, I could walk there from here.
Right. But the problem is back in 2023, which is why you're here where you are now, you didn't do that.
The court wants to make sure
I was arrested before I got a chance to do it.
we just want to make sure you can get back to court safely.
And just so that we're clear, I issued a bench warrant for you April of 2023, which was my third bench warrant I had to issue for you because you didn't show up. We didn't hear anything from you for about a year. And then you ultimately, like you said, got arrested. And then that's how this case finally had been set in April. And
I'm sorry.
that's where I put the bond in. So I'm trying to make sure that if I do release you, that there's a mechanism in place to make sure that you get down to court. I understand that you don't live that far, but I have to make sure that you're going to get back to court. So hopefully we can get some of that stuff in place. And I'm just, instead of adjourning it out 2 or 3 weeks, I'm just going to put it out 1 week. Okay? All right. So I'll adjourn it to July 3rd, 2024 at 9 a.m. All right? Thank you.
Thanks.
Okay, I'll talk to the folks at Admiral. July 3rd, we'll come to the judge again.
Yes.
Is that you?
Yeah.
Oh, yeah. Come on up. It's your time.
Able to talk to you. So.
You haven't?
No,
Okay, you can talk to me.
Yeah. That's
What's your... No, you don't really want to talk to me. Take your hands out of your pocket.
Thank you, Your Honor. Assistant Public Defender Natalie Pate, on behalf of Mr. Watts, please state your name for the record, sir.
Walter Watts. Thank you.
Thank you, Your Honor. The number we had on file for Mr. Watts unfortunately belonged to someone else, but now that we've made contact with him, we'll be able to further discuss this case. So we're respectfully requesting an adjournment.
July 17th, 2024, 9 a.m.
Are you sure that that was accurate? I'm pretty sure
I
that.
don't know what number got them, but if you want me to, we'll just proceed today. But I think you might want to talk to your attorneys before we start moving forward.
Yeah.
Yep, we'll discuss it in the hall.
Right.
There's a lot to discuss. Thank you, Your Honor.
Thanks.
Thank you.
Defender Lauren Franny on behalf of Mr. Smith. Where Mr. Smith is not present, I got a message from his father saying he's been hospitalized at a hospital in Indiana. He was transferred from U of M psychiatry to another psychiatry hospital in Indiana. I did provide that communication to Ms. Barroso, who would be asking for adjournment.
I have no objection to the adjournment. I did ask that the father provide proof at some point, but based off of that information, I see no reason for a bench warrant today.
Cool.
I did ask for proof, and I'll provide that to the court.
Okay. I'll adjourn it to the 17th. Why does everybody get no taps? I have a heart.
You just haven't had your coffee.
What?
Did you get your coffee?
Finally.
Oh, okay. Well,
But now I'm out of water. It's just the whole thing. No, that's fine. I got water. I got water. No, it's okay.
There's a lot of water in there.
Not a lot. There's some. A lot is relative. How's the case?
This courtroom hearing took an unexpected turn when the judge confronted a defendant over years of probation violations. The court heard that he had failed to report, complete required classes and community service, and provide proof of employment and education. He also had additional pending cases. His attorney asked the judge to consider ending probation without any additional jail time, pointing to his recent employment and the time he had already served. But the judge wasn't focused only on the money. He wanted to know why the court's previous requirements had not been followed. When the defendant explained that he had been all over the place and was trying to clear his record, the judge reviewed the situation carefully. Then came the decision. The court agreed to discharge him from probation, but sentenced him to 93 days in jail, giving credit for 13 days already served. What began as a request for leniency ended with a very different outcome.